You get a phone call from Joe Sixpack, who's got some property that is subject to an area for community redevelopment. He wants to hire you. What's the first thing you do? Well, if you're like me, you put your golf club back after you've been practicing indoors, set your scotch down, and you go researching the case law about what public purpose says and what your opportunities are to challenge the taking. What I'd like to do is to talk a little bit about the timing of the challenge first, a couple of the statutory issues that are created in Chapter 163, and some of the procedural issues which are now created under the amendments to Chapter 73. The first thing you need to decide when you represent a client whose property may be subject to an acquisition for community redevelopment is a timing issue. When do you challenge, if you do challenge, the acquisition of the property? Traditionally, one would think that when the condemning authority files its petition, under Chapter 74, as is usually the case, you litigate the issues of public purpose, necessity, good faith estimate of value at the order of take hearing, and the court will decide that. When it comes to a community redevelopment project, if you're representing the property owner, I would submit that you've got some other issues you have to address. The first is whether or not you should challenge the finding of blight before the condemning authority files its lawsuit. In fact, there's a case that I just came across. It's not in your materials. It's not even cited. It's RACUB, R-U-K-A-B, versus City of Jacksonville. It's a first DCA decision, 00-4593 is the case number, so there's no citation on that. But the issue in that case is whether the property owner was required to challenge the blight finding when the blight finding was made. Typically what happens in a redevelopment project is you have a bastion of consultants who prepare this blight study, and several years before the condemning authority, the redevelopment agency, begins its acquisitions, the redevelopment agency or the municipality sitting as such will adopt a resolution of a finding of blight. And the argument in the City of Jacksonville case, which I just cited to you, is the owner in that case attempted to challenge de novo the findings of blight and public purpose in the context of the order of take hearing. And the condemning authority in that case said, there's already been a legislative finding of that 15 years ago in 1985 when the blight resolution was adopted. And if you wanted to challenge the finding of blight, you needed to challenge it as presumably a suit for injunctive relief or declaratory judgment challenging the city's resolution of blight. Now that creates a number of practical problems for the practitioner. Let's say you have a situation where it's 1985 and the city or the redevelopment agency adopts its initial resolution of blight. They don't act upon it, as is often the case, for 15 or 20 years. It's 1999 or 2000 or 2001 or 2002, and the city adopts a subsequent resolution authorizing its staff to acquire the property through the exercise of its eminent domain powers. In between that period of time, a client of yours buys into this area in 1995, say, for instance. Well, he wouldn't have had standing to challenge the blight finding in 1985 because he doesn't own the property. He wouldn't even know about it. And now you have the situation of whether or not he has the opportunity to challenge the blight finding in the context of the lawsuit. The city is going to take the position that all challenges had to occur as a direct challenge to the blight resolution, which had been adopted years earlier. What's the option? The only thing that I would suggest from the perspective of representing either the property owner, and this is another issue which I think might be a potential defense to a challenge in an order of taking, is Chapter 163-361 authorizes a community redevelopment agency to amend its plan. So I think as a practitioner, you should be aware of that, should advise your client that he may want to consider requesting that a community redevelopment agency amend its plan to exclude the property from the redevelopment area, or to use that as an opportunity to again challenge the blight findings that had been made years before. Otherwise, you face the situation of being in court in an order of take hearing and some condemning authority raising the argument, as the city of Jacksonville has in its case, that any challenge to the blight finding is a challenge to a legislative decision which had been made before the suit had been filed, several years before the suit had been filed. Another opportunity that you may have to challenge a blight finding before the lawsuit is in a bond validation proceeding, appearing and objecting to that. Again, these are issues that you need to work out with the client because there are consequences if you lose. If you lose on any one of these issues, the owner is obviously going to be responsible for payment of his or hers attorney's fees and costs. That's obviously not an option. It's obviously not an issue if you're challenging a condemnation case. But I think as a matter of the responsibilities that attorneys fulfill to their clients, they need to give them the option and the pros and cons of a direct challenge before the suit's filed versus one that's raised after the fact. When I talk about challenging community redevelopment plans, I think that it's important that we frame the issue in terms of how are we going to challenge it. I think Jim has pointed out the practical limitations that any practitioner has if they're going to mount a challenge based upon public purpose. In Florida, I guess the Marvin case, which is cited in the materials, the 1938 case was the first instance when the Florida Supreme Court had had the opportunity to deal with redevelopment projects. That was actually a project to clear a slum, but I guess in Florida the leading case is Adams versus Housing Authority of the City of Daytona Beach. That's one of the leading cases. It's cited at page 4.8 of the materials, and it's a 1952 Florida Supreme Court case. In that case, the issue of public purpose was raised. And what the court said, I think, is something that is interesting. At that point in time, the court distinguished between the concept of police power and the concept of the state's eminent domain power. And the court wrote in the decision that if the purpose of a community redevelopment project is to eliminate blight or slum conditions, you can use that through nuisance abatement, you can use it through other sorts of remedies, and it went at great length to talk about the fact that there are adequate provisions in the Florida statutes with reference to the abatement of nuisances and the preservation of areas which do not require the government to exercise its eminent domain power. So what the court was saying was that there's an adequate remedy for the government to deal with issues of slum and blight by resort to its police powers if there's effective enforcement. And it's interesting that Jim talked a little bit about the Berman case. If you go into the Supreme Court archives and review the briefs that were cited by the parties, the property owners in the Berman case cited to the Adams case. Incidentally, if you read the Berman case, they don't even discuss the Adams case, and it's not surprising. Justice Douglas in his decision essentially rules in Berman, and this is picked up in later decisions, that the eminent domain power and the police power are coextensive, and that the eminent domain power can be used to effectuate a means, it can be used as a means to effectuate the state's police power. Then in 1959, I guess in the Grubstein decision, you have the Florida Supreme Court effectively retreating from the decision in Adams and no longer drawing the clear distinction between remedying slum or blighted conditions through police powers, i.e. nuisance abatement, versus condemnation power. So I guess the bottom line is that I think any practitioner who wants to challenge a condemnation case that's brought for community redevelopment is going to have a very difficult time, if not impossible time, to do it on public purpose bases. If you're representing the Community Redevelopment Agency, at least that's an issue that I think you've got a hand up on. What are the ways then to challenge a community redevelopment? You can't make the argument that my property is not blighted. Jim pointed out, that was the argument that was made by the property owner in the Berman case. In addition, in Florida, and this case is cited in the materials, we have Post versus Dade County, which is at 467 Southern 2nd, 758. In that case, the government was able to overcome the argument that my property is not blighted and I should be able to opt out of the community redevelopment plan. The concept is that these areas require such a broad, extensive, comprehensive method to deal with slum and blighted conditions that it's not an effective way to effectuate that by letting a property owner opt out merely by saying that the property owner's property is not blighted. I think your opportunities to challenge the taking relate to examination of the redevelopment plan. Under Chapter 163, a community redevelopment agency is required to implement a plan. If there's an inconsistency in the plan, then you can use that as an opportunity to challenge a taking. An example of that is City of Jacksonville versus Maimon, which is cited in the materials, where the city effectively had a piecemeal redevelopment plan. Parts of the area were blighted, and were subject to redevelopment. Other areas, the city effectively opted out. Then I think that the other areas to look at are actually to the statute, and these, there are no cases that have construed this, but I'd like to suggest a reading of the statute which may provide an opportunity to challenge a taking, and it's also, I think, an area that if you're representing a redevelopment agency, and I represent both, so I've got to be careful to look at it from both sides. I think this is an issue that you need to look at from the standpoint of whether or not your community redevelopment plan can withstand a judicial challenge or can withstand judicial scrutiny and a challenge from the owner. The statute has at Section 335 findings, and these are cited in the materials, legislative findings by the legislature when it adopted Chapter 163. And one of the more significant findings is that, and this is at Section 163, 335-2, it is found and declared as a matter of legislative policy that certain slum and blighted areas or portions thereof may require acquisition, clearance, and disposition subject to use restriction as provided for in Chapter 163, since the prevailing condition of decay may make impracticable the reclamation of the area by conservation or rehabilitation. What I suggest is that you should scrutinize that statutory provision very closely, because the language seems to contemplate that before there's an acquisition of property or a disposition of it, there must be some sort of finding that the prevailing conditions of decay make it impracticable to remedy that blight or slum condition through rehabilitation or conservation. So it's almost as if the statute is suggesting, and there's no case that has yet construed this, that condemnation is not necessarily the first resort to effectuating a community redevelopment plan. And I would think that as a matter of just due diligence, if you're representing a community redevelopment agency, your condemnation blight study should include a finding or a recommendation from the consultant that it is impracticable to reclaim the blight or slum area through any means other than acquisition. I think and that's somewhat consistent with almost the theory that lied behind the court's decision in Adams, distinguishing between police power and the power of eminent domain. I think there's further support for my argument or my suggestion in the definition of blight. That's at the materials. I believe it's at page 4.3 and 4.4. A blighted area is defined by the statute to be an area in which there is a substantial number of slum, deteriorated, or deteriorating structures and conditions that lead to economic distress or endanger life or property by fire or other causes, or one or more of the following factors: that substantially impairs or arrests the sound growth of a county or municipality and is a menace to public health, safety, morals, or welfare in its present condition and use. And it goes on to list 8 statutory factors, which are predominance of inadequate structures. The major one is that you've got too many small pieces of property in an area, which affects or makes it impractical to assemble those properties and devote them to a more to a higher use, or to a use which has a higher and better use than their current use. The statute, by using the words and in terms of that these conditions, these factors must substantially impair and arrest growth and are a menace to public health, safety, and morals, seems to me to suggest that you can't, and this is what you see a lot of times in blight studies, just a listing of these 8 factors without another finding in the blight study that these 8 factors in fact substantially arrest growth in the area. And in fact, the Jacksonville case, which I cited to you up on appeal, the very argument that the property owner wanted to make in that case is that the consultant who prepared the blight studies upon which the city made its findings never had in those studies a specific finding that the presence of those 8 conditions would substantially arrest growth or would have an adverse impact on the municipality and would constitute a menace to health, safety, or welfare. So there has to be, I believe, a nexus between those 8 factors and the presence of those conditions, and a demonstration that those 8 conditions, in fact, will impair or arrest growth and constitute a menace to public health, safety, and welfare. Because I believe that if you don't have that, and if the court concludes that you have the opportunity to challenge de novo the blight finding, the legislative blight finding, what has generally happened is that those blight findings have been made years in advance of the condemnation case, and you don't have the opportunity just before an order of taking to go back in and correct those in your blight studies. Also, I would point out that if you are going to avail yourself as a property owner of the remedy under Chapter 163, I call it a remedy, under 361 to request that the Community Redevelopment Agency amend its redevelopment plan, my suggestion, the way that I would approach it and do approach it, is basically you'll have a copy of whatever it is that constitutes the municipality's redevelopment plan. You'll have included in that the consulting reports that were prepared by the land planners, the appraisers, the marketing experts that the condemning authority relied upon, and you need to go out and to retain similar experts to provide you with an opinion which you can use as further support to request that the agency amend its redevelopment plan. And understand that the purpose of requesting the city to amend its redevelopment plan obviously would be to do it in a manner which would exclude your property or a certain portion of the redevelopment area in which your property lies from the plan, by showing that these conditions, these 8 conditions, are no longer present, and that therefore the condemning authority should amend its plan. There is a distinct risk in doing that. If you lose, then the condemning authority can argue, that we've looked at this issue, we've considered amending the plan, and we're not going to amend the plan. That may become, as a practical matter, even more of a difficult burden for you to address if you want to challenge it at the context of an order taking. There's another purely practical problem if you are representing a property owner and it is your desire to get the necessary experts to do that. It's simply the cost of doing that. As an example, I'm involved in a community redevelopment project in the city of Daytona Beach, where we're representing some owners, and we're also in a cooperative position. We're in a cooperative position with a developer who was submitting the redevelopment plan. And the way that these things start is that under the statute, the Community Redevelopment Agency will submit a request for proposals to various developers. They will respond to the request for proposal. A consultant will generally assist the city staff and the redevelopment agency in selecting who the appropriate developer should be to redevelop the area. And they prepare, in response to the request for proposal, a document which is generally something like this. And this is, in fact, a copy of the response to the Daytona Beach request for proposals that was submitted in conjunction with my clients, Trammell Crow, large real estate developer, and RealVest. And there was economic data that supported their proposal. There was data that essentially tracked the statute. There was work that was prepared by marketing consultants, appraisers, economists, and that's a 6-acre plus or minus redevelopment area. And this book with consulting work was approximately $350,000 to do it. So it's very expensive, I think, to do it right. And if that's just kind of an indication of the sort of magnitude of what I think you'll be up against if you want to represent a property owner and you're going to request that the redevelopment agency amend its plan. You're going to need the necessary experts to do that. I'm not saying it's going to cost $350,000, but it is going to be expensive to do that. And you have to decide whether or not, and the client has to decide whether or not they want to pursue that. There's another issue that I think again kind of dovetails with Section 335, which is the legislative finding about blight and acquisition, and Section 348, which is the definition of blight, and that is Section 163.345. And Section 163.345 establishes as a policy in the Community Redevelopment Act that community redevelopment agencies should do what they can to encourage diverse private enterprise and ownership in areas. And I think that if you look at that statutory provision in conjunction with Section 335 2 and Section 348, it lends further support to the argument that you shouldn't be too anxious to assume that the first method of remedying blight is through acquisition, because if you've got to promote private enterprise within a community redevelopment agency as a policy, then acquiring property and turning it over to a private developer who will then devote that property to a different use, to me seems inconsistent without at least a finding that it's impracticable to allow for that private enterprise through redevelopment efforts which are designed to conserve or rehabilitate the area short of acquisition. The other issue that may be an opportunity for a challenge is to review the actual developer's agreement. Typically what happens in a community redevelopment plan is that the property is subject to a developer's agreement, which is an agreement that's negotiated between the redevelopment agency and the developer and sets out the cards that each party brings to the table and sets out a plan for the acquisition. There's a case, it's not a condemnation case, it's the Stryton case that's cited in the materials, and it's essentially a breach of contract issue. But there's dicta in the decision that suggests, and it was very clear, that the municipality cannot delegate its powers under the Redevelopment Act to a developer. And you need to look at the developer's agreement to see whether or not there's an improper delegation. And I'll tell you why. I just came across on the internet, it's not in the materials because it just came out. It's a decision from the New Jersey Superior Court. It's called Township of West Orange versus 769 Associates, and that is, you can find that at lawlibrary.rutgers.edu, lawlibrary.rutgers.edu. And in that case, it was a community redevelopment plan to deal with Atlantic City, and the developer's agreement gave to the developer the timing, the control over the timing of when the acquisition would take place. In other words, the developer would tell the city at what point in time to condemn the property. And the court there said that the decision to acquire property, including the timing of acquisition, is a matter that is delegated by the legislature to the governmental entity that is vested with that power. And it's an improper delegation of that power if you attempt to do that into a developer's agreement to give the developer control over the timing of the acquisition. And I would venture to say that nobody has yet made that argument in Florida, and I think that if I were to go ahead and look at about 10 at-random developers agreements here in the state of Florida, about 5 of them or 6 of them would probably give the developer the control over timing. And that becomes an issue because if it's dismissed, you really put a monkey wrench into the acquisition plans because you have to go back and redevelop a whole new developers agreement. That probably takes a 90-day period of time to draft developers agreements. You have to change that. You have to go back and perhaps even start the acquisition process all anew. I would also lastly caution you to, if you're representing the property owner or the condemning authority, to look at the recent statutory revisions as it relates to good faith negotiations. The case law is not developed in the state of Florida, but there's abundant case law in other jurisdictions which deal with statutes which require good faith negotiations. They are jurisdictional prerequisites. And if the agency in some way is in a relationship with a developer and the developer is negotiating in a manner inconsistent with the eminent domain statutes, I suppose that it's not going to be long before somebody raises that as a challenge in a redevelopment plan. I think that is my time period, and I thank you for your attention. Thank you. We have 1 minute left, so I leave that to the chairman's discretion. If there are any questions, yes, sir.
Yeah, I've got a couple questions for you. Please repeat.
But go ahead.
Would you agree with that?
Yes.
Premise? Okay. Could you repeat?
The question, the comment was that Chapter 163 in the delegation of the eminent domain powers restricts that to the geographic areas of the redevelopment agency.
And only certain entities have been delegated that authority. For example, a school board couldn't condemn within the geographic boundaries. Would you agree with that premise?
Yes.
Okay.
And he asked me if I would agree whether a school board could condemn property for redevelopment purposes in a geographic area. They are not by definition a redevelopment agency, a school board. All right, thank you.
Welcome back to the afternoon presentation of our eminent domain seminar. We're going to start with the first topic this afternoon being what is the relationship between severance damages and police power regulations. We have 2 speakers. The first speaker will be Gerald Metters. The second speaker will be Robert Gill. Gerald Metters has presented various topics at statewide Florida Department of Transportation eminent domain meetings. He has been a senior attorney with Florida Department of Transportation in Bartow and an assistant attorney general for eminent domain for the FDOT in Tampa. He presently represents Pinellas County in Public Works and Property Rights Law. Bob Gill is a graduate of Northwestern University, where he received a BBA with high honors in 1971 and received his law degree from the Illinois Institute of Technology with honors in 1974. Bob concentrates his practice in diverse and complex commercial litigation. And Bob's trial experience includes more than 50 civil jury trials and numerous non-jury trials in a broad range of commercial litigation and commercial disputes. He's represented plaintiffs and defendants in issues involving eminent domain, land use and zoning issues, environmental and hazardous waste issues, public utility acquisition, and rate matters. Bob's practice includes the representation of government agencies and property owners, and Bob is a board-certified civil trial lawyer and business litigation attorney. So with that said, we will first hear from Gerald.
I'm going to be talking today about severance damages. I'm going to try to put severance damages into a rational framework under Florida law. Some of you are going to be saying that just simply can't be done. Others of you will say, how is he going to do that in 25 minutes? We'll see how it goes, and Bob, of course, is going to follow me, and he's going to do what he has to do. I'm going to discuss severance damages, police power regulations, and consequential damages. I'm going to present these issues from the condemnor's perspective. Takings cases are sometimes categorized, as they are, for example, even in this seminar, either as access cases or inverse cases, proximity cases, nuisance cases, probability of rezoning, or land use cases. My analysis of severance damages will cut across these categories. We're going to talk about what severance damages are and what they are not. We're going to talk about compensability and non-compensability. Time doesn't permit me to discuss the facts of the cases very much, but I'm going to be talking about the relationship between certain important cases. So let's begin. What are severance damages? Severance damages are the reduction in value of the remainder caused by a taking. In Florida, you have to have a taking to have severance damages. Now this sounds simple and easy to follow. It has not been simple or easy to follow in the cases in Florida. The concept of a taking has caused confusion. Surely, you're saying, he must be joking. Surely everyone knows what a taking is. No, ladies and gentlemen, not everyone knows what a taking is. A taking is a deprivation. Many things flow from this simple definition. Cases defining deprivation are Pinellas, 420 Southern 2nd, 308, and HRS, 418 Southern 2nd, 1032. Who is deprived? The owner. Of what is he deprived? The property taken. So a taking is a deprivation of property. Thus, severance damages are damages caused by a deprivation of property. This is important because severance damages are limited to damages caused by a taking, and a taking is a deprivation. The final definitional relationship I want to discuss is between the part taken and the remainder. Severance damages aren't just any old damages caused to the remainder by just any old thing. In early cases, severance damages were limited to damages resulting from actual physical intrusion onto the remainder. Orange belt, reduced size or shape of the remainder. Zitruer, or interference with riparian rights, as in Worth. Severance damages are damages caused by loss of ownership and use of the part taken in relationship to the remaining property. Severance damages are what you can no longer do with the remainder because of the absence of the part taken. Can you have damages caused by a public works project that are not caused by a taking? Of course you can. And here we are making an important distinction between what I've called a project and what I've defined as a taking. We are also distinguishing between damages and severance damages. Not all damages are compensable severance damages. Are damages caused by a project severance damages? Of course not. See Selden, Bowden, Jehoda, and Benaroff. Damages that are not caused by a taking can be called consequential damages. This means that they are the consequence of a legal act. It means that they are damnum absque injuria. In Florida, the term consequential damages is a term of exclusion. It means that those damages are not compensable. Incidentally, business damages are a type of consequential damages. They are not compensable but for Chapter 73 of the Florida statutes. See Texaco 537 Southern 2nd 92. Some of you may be thinking, what about interference with abutters' rights? Abutters' rights are private property rights of light, air, view, and access for property next to a road. Surely, some of you say, interference with abutters' rights causes severance damages. My answer is that abutters' rights are subordinate to the rights of the public under the police power. See Selden, Bowden, Anderson, Jehoda, Milford, Capitol Plaza, Benaroff, Lewis, Martin County, Stubbs, ABS, Frenchman, Ness, Tesler, Weaver Oil, Suit City. You don't get severance damages for what happens in the part taken. What happens in the part taken is not the taking. You don't get severance damages for what the project does. What the project does is not the taking. This may come as a surprise. Let's mention some of the things that are not compensable. Reductions of access and driveways, putting up a gravity wall and handrail, putting in a median, realigning the main line, putting the property on a service road, elevating or lowering the road, installing curbs, putting in a retention pond, putting up a fence, putting down pavement. Everything in the right-of-way is based on police power regulation. Think about it for a minute. Who owns the part taken? The condemnor. Some cases distinguish between de jure and de facto cases, holding that consequential damages are only compensable in de jure cases. However, de jure and non-de jure owners are similarly situated, and a proper analysis of the cases shows this. Rubano, an inverse case, and an access case, relies on Capitol Plaza. Benaroff, a de jure case, relies on Bowden, which was an inverse case. The principles apply across types of takings. Consequential damages are consequential wherever they are, whether there is a de jure taking or not. Police power regulations are police power regulations wherever they are. As President Bush said this week about liberty and justice, these concepts are right for all people everywhere. If these concepts apply everywhere, what about on the remainder? Bingo! What about police power regulations affecting remaining property? Damages caused by police power regulations affecting the remainder are not compensable. I will call these consequential damages on the remainder. Now, some of you are thinking, surely he must be kidding. Surely we've got him now. Surely he can't mean that we can't talk about zoning requirements on the remainder. Owners' lawyers, and in this case, Bob happens to be acting as an owner lawyer, now trot out cases such as Duval, where the court confused eminent domain with police power taking. They trot out Lewis and national advertising, which are also regulatory takings cases. They are not eminent domain cases. The owner lawyers then say, including Bob, what about Patel and reasonable probability of rezoning analysis? And I say to them, the principles of law are the same, whether we're talking about the part taken or the remainder. Recall that we said police power regulations are police power regulations everywhere. The cost of compliance with police power regulations of remaining property, grandfathered or not, is not compensable or admissible. Read Martin County, see Bennett, Malone, and Trevor Michelin. What about Patel? In Patel, the county attempted to show the likelihood of obtaining a variance as part of a cost to cure severance damages. Patel says, quote, while Florida's long recognized that the reasonable probability of rezoning may be considered when determining the value of condemned property, we see no reason why it may not also be considered in determining severance damages. Apparently, the Supreme Court was not properly referred to its prior rulings on consequential damages and police power regulations. This outline has shown why probability of rezoning, and particularly of obtaining a variance, are as species of compliance with police power regulations should not be compensable in eminent domain. See the cases already cited. This has broad implications. The highest and best use analysis contains the legal permissibility factor. If this non-compensability creates problems for analysis under highest and best use, then that analysis needs to be revised. The Patel opinion also had some other problems when it said nobody has a duty to mitigate anything. Some, including Carrie Gaylord's group, said they were talking about the duty itself and had abolished it. Others, including Ellen Kombacher in a CLE International, said they were talking about not having to build a cost to cure. Who knows? But Patel has other problems. Now, some of you have had time to think. He's forgotten about Wye River. The plans for the project are admissible under Wye River. If they don't offer the plans, we can assume the worst possible consequences. I think we've heard those words mentioned today. That word consequences again. The plans shouldn't be admitted because they aren't relevant. The plans normally, almost always, should be inadmissible because they aren't relevant. And because the owner bar uses them mainly to allege consequential damages. Wye River was wrongly decided. Wye River and its progeny should not be followed. What is being placed in the part taken is irrelevant because it's consequential damage and subordinate to the police power. Thus, the worst possible consequences referred to in Wye River are inadmissible because they aren't relevant because they're consequential. Wye River also states, incidentally, that all damages which are not merely consequential, and Wye River uses that word, are recoverable. All damages which aren't merely consequential are recoverable, says Wye River. However, this is the very definition. However, Wye River then cites Nichols, believing apparently that the citation from Nichols was the definition of severance damages in Florida. This very definition is the definition of merely consequential damages, which are not admissible in Florida, even under Wye River. Quote, this is from Wye River. The law takes into consideration all conceivable uses to which the property taken could be put by the condemnor. Florida law, ladies and gentlemen, explicitly does not take into consideration the uses which the property taken could be put. Wye River was later followed, nonetheless, in Trailer Ranch. The Supreme Court was again apparently not referred to its prior rulings regarding severance damages. Wye River had also relied on Doty, an old Supreme Court case, for the proposition that plans are admissible. In Doty, the court required plans to show a proposed grade in the part taken. The reasoning and authority for Doty are weak. It is inconsistent with Bowden and Selden as well as later cases. Doty relied, in turn, on Chicago versus Lord, where the plans were relevant in this Illinois case to show joint use of the easement taken. In Doty, however, there was no joint use on which to base relevancy for plans. There was no basis in Doty for overriding the police power regulatory authority over the part taken. However, if the condemning authority places the plans in issue by claiming a special benefit, exclusion of plans would be waived. Now, you owner lawyers are desperate, right? Casting about for anything to use to claim that consequential damages are compensable. After all, most claims for damages in eminent domain in Florida are based on consequential damages, aren't they? Time to trot out City of Tampa versus Texas. City of Tampa versus Texas cited from other jurisdictions a rule that the use of the part taken was compensable, and the exception, once again from other jurisdictions, that use of land taken from others was not compensable. City of Tampa went on and on about consequential damages. It went on for pages. But in the end, after all that, after all was said and done, it made no application whatsoever to its facts of these vast and rambling pronouncements. Owner lawyers are now saying, City of Tampa, I missed one brief remark on City of Tampa before we quit City of Tampa. City of Tampa stands for nothing in the law of severance damages in Florida. Owner lawyers are now saying, what bastion of severance damages is he going to attack next? You guessed it, folks. Dade County versus Brigham and Jacksonville Expressway Authority versus Dupree. All facts and circumstances bearing a reasonable relationship to the owner's loss should be considered. How can he get around that? Martin County, ladies and gentlemen, limits the expansive severance damage language in both Dupree and Brigham. After Martin County, damages based on all facts and circumstances explicitly excludes consequential damages. Explicitly excludes consequential damages. Martin County finds that consequential damages don't bear a reasonable relationship to the owner's loss. We are going to move on now to so-called access cases. These have been a fertile field for consequential damage case law. The right of access to a highway is a private right. Traffic flow or passage is a type of public right. Stubbs held that access did not include a right to traffic flow, even though commercial property might very well suffer adverse economic effects. Folks, adverse economic effects are another word for consequential damages. Let's look at Capitol Plaza. This is a very important case for understanding the spread of consequential damages law in Florida. In Capitol Plaza, the Supreme Court distinguished a compensable taking of access from a non-compensable regulation of traffic flow. Capitol Plaza has been misinterpreted to appear consistent with consequential damages because the median in Capitol Plaza was in pre-existing right-of-way rather than in the part taken. This reading of Capitol Plaza is not supported by the opinion. It's important because most of the cases allowing consequential damages are based on misinterpreting Capitol Plaza. Lee County was based primarily on misinterpreting Capitol Plaza. Lee County accepted a consequential damage standard by distinguishing Capitol Plaza. Cases applying consequential damages based on misinterpreting Capitol Plaza include Lee County, Partika, Hupschman, Taylor, and Armadillo, among others. Capitol Plaza talked about traffic flow. The term traffic flow means traffic flow wherever it is, whether on pre-existing right-of-way, on taken property, or adjacent to untaken property, as in Selden. When Capitol Plaza stated, this state has joined the numerous other jurisdictions which have found that a landowner has no property right in the continuation or maintenance of traffic flow past his property meant past his remaining property in a partial taking case. If that were not the proper meaning of traffic flow in Capitol Plaza, this would have placed it into conflict with Selden, Jehoda, Benarofe, Martin County, and Anhoco. The Capitol Plaza Court was at pains to distinguish traffic flow from access, which had been confused by the court below. In mentioning that the median was constructed in previously owned right-of-way, the point was to clarify that no access rights were taken and to distinguish Capitol's situation from Stubbs, a partial taking in which a land service road was coincidentally converted into a limited access facility. Look at the dissent in Capitol Plaza. If the median had been installed in the part taken in Capitol Plaza, the holding would have been the same, and the reasoning would have been the same. Conversely, if no land had been taken, the holding would have been the same and the reasoning would have been the same. Consequential damages are consequential damages wherever they are. I think my time is up, and I'll perhaps, if depending on how Bob goes, I'll have a chance to address you later.
Good afternoon. You just witnessed firsthand the clarification and rearrangement of 50 years of appellate jurisprudence. I can say that Jerry and I have litigated numerous cases together, and one of the perks of trying a case with Jerry is that he goes first. He's a good setup man. First of all, I want to acknowledge Jerry's contribution to the outline that is in the written materials. I got bogged down in 2 trials and an appellate deadline the last quarter of last year, and Jerry jumped in and literally wrote 99% of it. And I want to acknowledge that publicly, and also, of course, make sure that none of you think that I wrote the condemnee segment of these materials. One of the benefits of CLE, besides meeting our bar requirements, is to come to grips or become aware of the cutting edge issues that are going on in our field. And the genesis for today's topic really came from the last trial Jerry and I had. And what I'd like to do is kind of set up maybe 4 or 5 cases that you need to have in mind when you address this issue, and also give you the facts of the case that Jerry and I were involved in, so that you can see, in my view, how ludicrous it is to take the concepts that Jerry has aspired to and apply them to a real-life factual situation. It can sometimes result, and at least in the instance, the last trial that Jerry and I had, result in a very egregious set of facts and result. There are a series of cases that begin with the Florida East Coast Railroad versus Martin County case. And I'm not going to give you citations. They're in the text materials. But that case was one that evolved from a situation where the railroad, I think this particular crossing was in a rural area, and Martin County was going to make some redesign of the crossing. And by 1965, or the early 1960s, and this case was at the trial level, obviously technology had gotten to the point where you could have some fairly sophisticated and expensive crossing protection devices. And the railroad, as part of its claim, said, well, we don't really want to have to pay for that upgrade. The county should have to pay for it. And the Supreme Court disagreed with that, primarily on the basis that those are police power regulations that are part and parcel of conducting the railroad business, and you should have realized that hundreds of years ago when you got your franchise, and it's just part of doing business, and we're not going to make the county pay for that. What's interesting in that Florida East Coast Railroad case, though, is some very generous citations to a very old United States Supreme Court case out of Chicago called City of Chicago versus the Chicago, Burlington, and Quincy Railroad, 1898 decision, which in effect was a case where when vehicles, cars were coming into prominence, and they were trying to traverse railroad tracks, obviously something had to be done to make that ingress and egress more suitable. And the United States Supreme Court, in a very lengthy decision, basically came down and said, you know, when railroads got this property and this franchise that they have and almost quasi-monopoly, they accepted the burdens of having to conduct that business, and one of those burdens are that eventually people are going to want to cross their tracks, and they should have, the railroad, that is, should have to pay for that. So if you put that decision in historical context, you know, back then railroads were the modern day Enron, and it was sort of like the Ford family versus the Vanderbilt family, and you know, obviously the Ford family won that battle. So when the Florida Supreme Court, and it wasn't just the Florida Supreme Court, but many Supreme Courts around the country, just took that reasoning and took it one step further in determining that when it came time to make railroad crossings more safe, that it was going to be the financial burden of the railroads. Really nothing happened in Florida for about 20 years, and we come along in 1984 to a case called Malone versus Florida Department of Transportation. Interestingly, that is a full take case, and that's important to remember. And what was going on there is that a company that was involved in a grease processing business was going to relocate its business, And following the relocation, they were going to have to comply with some new OSHA laws or regulations, and they included that as part of their compensation. The court said no. Under the police power regulations, that's compliance with nothing more than compliance with police power regulations, and took the Florida East Coast Railway case one step further. Nothing happened then for another 5 or 6 years until FDOT versus Bennett. Once again, a full take case. And there the property owner wanted to recover as part of their land damages the enhanced value resulting from the fact that their property was grandfathered, enjoyed some grandfathered privileges that they didn't have to comply with, obviously, unless they moved to another location. Once again, the appellate court took Malone and the Martin County case that extra step and said no. Then in 1997, we had the Michelin case. And although it's not a full take case, it's a case where the property owner, as part of the land damage component of his case, argued that he was going to lose some parking spaces because now in 1997 he had to comply with ADA handicap parking requirements, and that as a result of that he would have fewer non-handicap spaces, and he wanted to claim not only the cost of complying with that, but the severance damage aspects of complying with that to the land damages. Once again, the appellate court said no, compliance with police power regulations are not compensable. So with that backdrop, we have the Florida Supreme Court decision in Broward County versus Patel, decided in 1994. And the facts of that case are essentially that the subject property was a motel on A1A located in Pompano Beach, and the construction of that hotel predated some Pompano Beach regulations that addressed the size and the number and the location of parking spaces. As a result of the taking, there were severance damages, and Broward County attempted to avoid those severance damages by presenting a cure plan. The property owner objected to the cure plan on the grounds that the city of Pompano Beach had never approved such a cure plan, and that the construction of that cure plan would not be permitted under the municipal ordinances unless there was a variance granted or some kind of a waiver. To address that issue, the county put on several witnesses which in effect attempted to establish the fact that there was a reasonable probability that those variances would be granted, i.e. the cure plan could be implemented and the severance damages avoided. The property owner fought that, and the issue before the Florida Supreme Court, as certified, I think, by the 4th District Court of Appeal, was whether or not a cure plan that required a variance or a waiver needed to be coupled with a testimony or evidence of a reasonable probability that the cure plan or the waiver would be granted by the local municipality. And interestingly enough, if you go online and get the briefs in this case, you'll find that the Department of Transportation submitted an amicus brief in that case on the side of Broward County, and the conclusion is in the department's brief is essentially that we urge the court to adopt a principle of law that when condemning authorities have a cure plan that requires a waiver, that it be coupled with a reasonable probability or testimony or evidence of a reasonable probability that the variance would be granted. And using the reasonable probability theory and reasoning and concepts that we have with the highest and best use and probability of rezoning, it didn't take much of an effort for the Florida Supreme Court to extrapolate that reasoning to the cure plan concept that we've been talking about. So those are the 5 cases that anybody who is going to be litigating this issue needs to be aware of. And I would caution all of you, whether you're on the property owner side, but especially on the property owner side, but also the condemning authority side, that when your adversary presents a cure plan that attempts to avoid the payment of severance damages, and that cure plan requires some local government variance in order to implement the plan, that you'll be aware of these cases, because you'll probably be met with some kind of a motion in limine, if not a motion during trial, when the evidence to support these cure plans are going to be presented. So that takes us up to the trial that Jerry and I had. The facts are that the subject property is located on St. Pete Beach, a building that was built in the late 1940s, about 2,200 square feet. The taking is going to take off approximately the first 6 to 10 feet of the building, and of course the department's cure plan is its good old cut and reface. Cut it off and put up some kind of a facade. At trial, the department's appraiser opined severance damages of about $110,000, and in an effort to avoid paying those severance damages, presented a cure plan of approximately $20,000 to cut and reface the building. The problem was that because the building was located in the city of St. Pete Beach, and because of the age of the building, there had been adopted by the city of St. Pete Beach regulations, what we call FEMA regulations, which for those of you who don't understand that, it simply is, FEMA is that federal organization that provides property insurance to areas that private insurance companies don't want to assume the risk. However, if you are a community that has the benefit of FEMA insurance, you're required to make sure that whenever some remodeling or some reconfiguration or reconstruction of the building occurs, that building must meet the current standards or the current codes with respect to waterproofing, wind damage, etc. It's an effort by the federal government to make sure that people just don't reconstruct the same building after it's destroyed using, old materials and old concepts of protection, and thus minimize the risk that building would be damaged again in the future. So the backdrop in our case, of course, was that there had to have been a FEMA compliance with this building, because its current value was approximately $45,000 or $50,000, and it was going to cost at least $20,000 if you accepted the DOT's presentation to do the cut and reface. And of course, the property owner had a different cost figures to implement that cure. Well, what happened was a motion in limine whereby the Florida East Coast Railroad case, Malone, Bennett, and Michelin were presented to the trial judge, and the trial judge says, well, that's right. This is just nothing more than compliance with police powers. And, it's just a shame that these police power regulations are now in existence, but, it's those police power regulations, Gil, that are causing you the problem. It's not the taking. The taking hasn't caused any of this. I, of course, immediately brought up the Patel case, and the Patel case was distinguished by the department and accepted by the trial judge on the basis that there is no language in the Patel case that indicates that you were dealing with a grandfather provision. Granted, the words grandfather rights are not in the Patel decision. However, they're in the briefs, and it's clear to me from the facts in the Patel case that you were dealing with a building that predated, the construction of the building predated the enactment and the adoption of some certain regulations that needed to be complied with after the taking. So, needless to say, I lost that argument. The case proceeded to trial, and the jury, of course, heard 2 cure plans. Their perception, because I was not able to tell the jury that the cure plan that was being proposed by the DOT contained some requirements that they get waivers from the local municipality, and there was some good probability that they would not be granted. In fact, I subsequently found out that the city of St. Pete Beach has never, ever in its history granted a FEMA variance, ever. And of course, the jury didn't find that out, and their perception was, well, there's just two cure plans here. The property owner is being greedy with this expensive one, and we have this reasonable one that the Department of Transportation is presenting. Obviously, the component of the verdict was pretty much right on the department's number. The case has been fully briefed before the second DCA. It hasn't been set for oral argument yet, and who knows what the outcome will be. But the purpose today is not really to, persuade you to my side or to attempt to say that the department's arguments had no merit. I think that they did. However, what you all need to be prepared for is to have these cases in your arsenal, be familiar with them, know how to argue them, know how to distinguish them, and you'll be better prepared when you stand up and try to address an objection to one of your cure plans on the basis that it requires a municipal variance. You better be prepared to be able to prove that it does, or if you're on the other side of that issue, that there's not a reasonable probability that would be granted. And that requires a lot of legwork and homework to go to the local government and find out what applications for a similar a cure have been made, and what is the percentage or how have they been disposed of by that municipality. And I think it's also important to know the type of police power regulation you're dealing with. It's fairly easy for a local government to be parochial in its thinking when they are looking at, say, a landscaping or an architecture or a building setback requirement. On the other hand, when they're dealing with a FEMA regulation, where they're going to be audited by the federal government, and there are economic consequences to the whole community in the event that the classification of their jurisdiction changes and the insurance becomes more expensive, it has a debilitating effect on economic development in that community, and the elected officials are going to take a close look at that. So in between those two parameters, there's obviously a lot of other police power regulations, the parking. You could go through a couple of dozen things that you might be confronted with, but so I guess the moral of the story is to have these cases in your files, review them, be prepared to address the issue, and you will better represent your client regardless of which side of the case you're on. Thank you very much for your attention. I guess we have some time left if anybody wants to ask Jerry or I a question. Jeff, I think you had your hand up first.
Good standing of the DOT, former DOT Attorneys Association, I've rethought trying the loan. I tried the loan for the DOT, and I was wrong.
Can we get this? I have to repeat that. Jeff Savlov has said that when he was with the DOT, he tried the Malone case, and he is sincerely and deeply apologetic to the rest of us for having done that. Okay, thank you, Jeff, for that acknowledgement. David?
A couple points. I had a similar problem down in Lee County, and Judge McIver allowed me to go forward with the evidence of the compliance and the police powers. And the way we spun it, if you will, to get around what Jerry's arguments were that the appraiser was valuing the after condition, and he wasn't seeking compensation on an item-for-item basis like these other cases. He was just saying, what would a reasonable buyer pay for something in the after condition if they had to renovate the building? And based on that, his after value was established. So we kind of put it in that box, and it was helpful to not have to deal with it directly as a line item compensation. Another thing on what Jerry said, you basically have to throw away that whole instruction on the use of the part taken. That's quite an extreme position. I'll be surprised if a judge wants to do that.
I don't think that's very extreme.
Well, we need to get all this on tape. The question was.
It wasn't a question.
All right. The statement was, it is a very extreme position for Jerry Metters to take that anything that happens on the part taken cannot result in severance damages. And I'm going to, since I agree with you, I'm going to let Jerry respond to that.
Rather than respond to that, David, I'd like to take the time to go through the rest of my presentation.
I tried not to make it a question.
There's actually some other things one could say about the problems with Lee County versus Exchange. It wasn't just a misinterpretation of Capitol Plaza. Lee County also ignored existing controlling precedent against consequential damages, including Bowden, Selden, Lewis, Milford, Anhoco, and Ware, and conflicting precedent in Ness, Benaroff, and Jehoda, among others. Lee County cited and misinterpreted conflicting precedent in West Palm Beach Garden Club. Look at West Palm Beach Garden Club. Quote, in the absence of an actual physical taking, end quote, means in the absence of an actual physical ouster from the remainder in West Palm Beach Garden Club and earlier severance damage cases. Owner lawyers like to trot out Partika. Let's look at Partika for a moment. Partika misinterprets Milford and misinterprets and conflicts with Capitol Plaza and other controlling precedent. Additionally, the severance damages in Partika were based on a county ordinance which under Martin County and Michelin and those others should not have been compensable anyway. So look closely at Partika. There are weaknesses in Partika. There's conflicting precedent within the second DCA on consequential damages. Look at Wedgie's Banana Boat, 576 Southern 2nd, 722. Second District found consequential access business damages not compensable, citing Ness in the opinion and Lewis in the concurring opinion. This opinion conflicts with Lee County, even within the Second District. Lee County and cases citing it are in conflict with controlling precedent in Florida and should not be followed. About the only thing Lee County should be cited for is that City of Tampa versus Texas makes no application of consequential damages to its facts. Okay. Okay, go ahead.
Yeah, under your interpretation of the law in this area, is there any circumstance under which a damage to the remainder could occur?
If it amounts to a regulatory taking of the remainder, surely. In Bob's case, where you had
Police power regulation.
it's police power regulation, but it's a regulatory taking of the remainder. If you can't use the remainder, if you're ousted from the remainder, that's the circumstance.
That's the only circumstance.
That's the one.
Let me ask
Regardless of whether a wall is constructed, providing access to the remainder.
Let me respond to that by saying that that surely can't be the law. If it is the law, the parameters of cure plans are limited to the creativity of the consultants that the condemnor can afford, because if a cure plan cannot be implemented, in my view, it does not mitigate severance damages. And I don't know how much more simpler it could be said.
Yeah, but under that circumstance, cure plans would become irrelevant because there would be no severance damage.
Well, you see, if you read City of St. Petersburg versus Caney, the concept is that a cure plan is a substitute for severance damages. And if you have a damage and you receive compensation in the form of a cost to cure, that doesn't mean that you have any obligation to implement the cure. It may be that you don't implement the cure, but that doesn't mean that you're not entitled to receive the benefit of the damages that are caused as a result of the taking.
For our next topic this afternoon, we have the title, It Ain't Over Till It's Over, Supplemental Proceedings, and Charlie Stratton and Jeff Savloff will be our speakers on the topic. Charlie Stratton will be speaking first. Charlie received his J.D. degree in 1976 from the University of Florida. Charlie's a member of the Florida Bar and the D.C. Bar. Charlie's both a past chair and vice chair of the Eminent Domain Committee of the Florida Bar and is a co-author of the trial portion of the Florida Eminent Domain Practice and Procedure CLE Manual. Charlie was an eminent domain attorney at DOT from 1979 to 1986 and served as the chief eminent domain attorney at FDOT from 84 to 86. Charlie currently practices with Broad and Cassell's Tallahassee office and represents owners throughout the state of Florida. Jeff Savloff had received his BA degree in 1970 and his JD in 1975 from Florida State University. Jeff was an assistant state attorney in 1975 and 1976, and he was an eminent domain trial attorney at FDOT from 77 to 81. Since 1981, Jeff has been in private practice, currently with the firm of Savloff and Anderson in Tallahassee. Jeff is a member of the Florida Bar, the Tallahassee Bar Association, and a longtime member of the Florida Bar's Eminent Domain Committee, of which he is a past chair. And he's practiced eminent domain on a statewide basis since 1977. Charlie?
Thanks, Paul. Good afternoon, everybody. I thought that there was some correlation between following directions and the presentations today. And I went back and got out this sheet the bar gave all of us, that's the course material specifications checklist. And instruction number 2 says include a short 100-word biographic sketch. And so I went back and looked at the biographic sketches, and Jerry's was real short. And Ken Davis's was like 200 words. So I guess there is no correlation. But, I don't know. I want to, before I start, thank my associate Gino Luzetti for helping prepare the materials. He was a big help to Jeff and myself. How did we come up with this title, Supplemental Proceedings? It ain't over till it's over. Well, it was interesting. When I was outside earlier today, John Tileston was talking to me, and Steve Moran walked up, and they said, nothing's changed in 30 years. It's always the same. All we ever talk about is attorney's fees. And I said, well, that's exactly right. Supplemental proceedings. And really, when we got into looking at it, it's all about attorney's fees. All roads lead to attorney's fees somehow. So that's really, to some extent, what this is about, and probably mostly what this is about. It's really a pretty narrow topic. It's, based on a statute, and there's not too many cases on the statute yet, but it's 73.092, parens 2. And like I said, it's pretty short. It deals with supplemental proceedings. So what are supplemental proceedings? Well, we all know that there's only 2 chapters in Florida statutes that deal with eminent domain. Chapter 73, which is titled Eminent Domain, and Chapter 74, which is titled, I want to get it exactly right, Proceedings Supplemental to Eminent Domain. So, you think anything under Chapter 74, a quick take proceeding would be a supplemental proceeding. But no, that's not quite right. In the LaBelle Phoenix case, which we'll talk more about, the legislature said, or pardon me, the court said, the legislature, they didn't really quite get it right because they didn't mean Chapter 74 as a supplemental proceeding in Chapter 73. They meant something else. And they did specifically state, to some extent, what they meant. I went back and looked because there's been an issue that's come up. What is a proceeding? Is a proceeding a hearing? And one of the places I looked was the place that you would expect someone who's not that smart to look, is Black's Law Dictionary. What's a proceeding mean? Go to the dictionary. So I got out Black's Law Dictionary, and lo and behold, a proceeding is not always a hearing. Sometimes it could be a hearing, but it's whatever leads to the progression of a case. So it doesn't have to be a hearing. Getting past that, because I've had attorneys argue, if you want to get paid fees for a supplemental proceeding, if you want more than your benefit fee, you've got to have a hearing. And that just didn't make sense to me. And so Black's helped a little bit on that. And I tried to come up with some other things that would help out on that. What else could be a supplemental proceeding besides a hearing? Well, some of the cases helped us out. Let's talk about a little bit about what 73.0922 says. It specifically mentions you get fees based on your hours and the other criteria in subsection 2 for defeating an order taking. That's pretty specific. And I think we all know what defeating an order taking is. That's easy, okay? Now, what if you do a motion to dismiss the petition and you notice it for hearing, and probably you're going to want to notice it for hearing at the same time as the order take hearing. And what if the judge grants your motion to dismiss? Have you defeated the order taking? Good question. Jim Anderson said, make sure you get an order at the end of the hearing saying you defeated the order taking with leave for the condemning authority to amend to come back. That would probably help you later on when you tried to get your fees for that. Even if you got an order from the judge saying, I'm denying the order taking and granting the motion to dismiss with leave to amend. I actually had one. I don't know. It doesn't happen very often. I've been doing this a long time, I guess. But I had one a couple years ago in the 4th District. We had an order to take hearing, went through the whole thing. Judge heard all our objections. I even put on some witnesses to try and stop the order taking. And when we got to the end, the judge said, well, I'm going to deny your motion. And he said to the DOT attorney, can I have the order? And the attorney gave him the order. And I said, Judge, could I see it before you sign it? And he said, oh, sure, you haven't seen it? Sure. Gave me the order, and I read through it. And he said, do you have any problems with it? I said, well, yeah, Judge, paragraph so-and-so, paragraph such and such. And I told him what my objections to the order were. And he said, you know, Mr. Stratton, you're right. Counsel, I'm going to deny the order taking with leave to amend. And I got an order denying the order taking with leave to amend. My client happened to be an attorney, and as soon as the judge said that he was doing that, I got him and got out of the room before the judge could change his mind again. So, and he was, you know, why are you dragging me out of here? Don't want the judge to change his mind again. But that was sort of unique because the case sat around for a year. I calendared it for a year and nothing happened. And so I came back in and moved to dismiss for lack of prosecution under the statute. And the DOT decided not to go forward with it. And the court dismissed it for lack of prosecution. Actually, we stipulated to dismissal after I got my fees paid. So they did pay the fees for that. And that was defeating an order taking. All I did was get the judge to say, I'm not granting it today. DOT, you have leave to amend. But I did get an order. The next thing the statute says, besides defeating an order taking, it says, or for apportionment. So we know if you have an apportionment hearing, and I've never had an argument with anybody on that, if you have a hearing. Now what if you spend hours and hours going back and forth, maybe even have a mediation, maybe not, maybe just an informal mediation between landlord, tenant, or whatever the interests are with the mortgage company, and a lot of you know that takes a lot of time sometimes to get that resolved, to determine who gets what share of the money. Well, the statute says for apportionment. It doesn't say for going to an apportionment hearing. If they wanted to send you to a hearing, they could have said that. But they didn't say that. The third thing in the statute is a catch-all phrase that says, for other supplemental proceedings. So that's sort of, you know, a catch-all clause. And one of the cases calls it basically fees for anything that's not provided for. It's taking care of any gap where there would be no fees except for that. One of the cases, LaBelle Phoenix, says that if there's no monetary benefits and no non-monetary benefits, then the only way to determine fees is under subsection 2, which logically makes a lot of sense to me. You can take a percentage of a monetary benefit. You can take a percentage of a non-monetary benefit once you reduce it to dollars. If you can't reduce it to dollars, if there's no dollars, it's got to be under subsection 2. Because you're entitled to be paid your fees. And anybody who doesn't believe that should go back and read Brigham again. If Jerry's still here, Jerry, you ought to read Brigham again. I read it again today. It's very interesting. It goes a lot farther than what people seem to remember about it. Now, does Section 2 require you to have a proceeding? Well, no. I said you don't have to have a hearing. Black's Law Dictionary says a proceeding doesn't have to be a hearing. We all know that general law is that the law favors settlements, not contested proceedings. We shouldn't be wasting a judge's time with a hearing just to make sure we get our fee paid. If we can settle something without going to hearing, we should still get the fee paid for doing that. And that's what the Smith-Bilt case says. It's the one that says there's a gap in the fees, and there's no monetary benefits. You fill that gap by using subsection 2, which is basically what the old fee statute was with the various criteria. The ABS case talks about fees in a voluntary dismissal. It was a situation where the parties got together and they worked out a deal before the OT. They were going to get things stipulated to. And they worked it out, but it was subject to being approved by the DOT. And when it got back to the DOT, it didn't get approved. If I remember right, it was a US 19 case, which anybody from around here knows have been problems for years. So ultimately, DOT said, well, we can't agree on the order taking. We don't want to go to a contested order taking. We'll just drop the project and dismiss the case. So they took a voluntary dismissal. They took their voluntary dismissal. The owner's attorney made his motion for fees. Subsection 2 doesn't say anything about fees in a voluntary dismissal. That's not defeating an order of taking. Where is it? It's not, there's no monetary benefit, there's no non-monetary benefit. The court said the only way to measure it is to fill in this gap and award fees under subsection 2. Court said there's no real difference between a voluntary dismissal and an involuntary dismissal. That didn't make a difference. And it said you look at that clause, when not otherwise provided for. You pay the fees under subsection 2 when it's not otherwise provided for. So that's how those fees were paid. Some of you may remember a gentleman named Irving Younger. Irving Younger used to give full-day seminars. It would be one guy would stand up and he'd talk all morning. You'd go to lunch and you'd come back in the afternoon and he'd talk all afternoon. The guy was a wonderful speaker, much better than I am, and he kept everybody pretty much awake. But I remember going to one of his seminars, and after lunch it was getting to be about this time, and we hadn't had a break yet. I can't remember if they took a break in the middle of the afternoon like we did, but everybody was starting to nod off and get a little tired like some of you are. And Irving Younger would start talking about sex to get everybody awake again. And it always seemed to work. And I guess we can't do that anymore. I'm not going to do that. But it's, you know, this is that time of day. People drinking coffee, getting some caffeine, and trying to stay awake. I guess, you know, to keep you awake, I could pass out. But Janet Reno did that yesterday, so that's not going to work. Okay, let's go back a minute here. One of these other cases that I wanted to mention to you was this LaBelle Phoenix case, and I know Jeff's going to talk about it some, but it's the one that basically says if there's dollars, do percentages. If there's no dollars, do it under subsection 2. The Smith-Bilt case is another one that dealt with this, and it talked about the gap also. This was a case where they settled the entire case except for business damages. There was no offer on business damages. They went to trial on business damages, and they got a jury verdict. Then they went back to get the fees on the business damage claim. Well, how do you get the fees on the business damage claim? They got money, so you know there's money. It should be a percentage fee. Well, they said that since there was no written offer, they couldn't determine what the benefit was because the DOT, the condemning authority, never made an offer. So they said consistent with the overall intent of the statute, and the overall intent of the statute is you get paid fees if you do the work, and to encourage and facilitate amicable settlements. As I said, you don't have to go to a hearing. You can work with the mortgage holder, get the money divided up. You can work with your tenants, get the money divided up. You don't have to go to an all-day hearing on apportionment. You can facilitate and encourage an amicable settlement in an eminent domain proceeding, that's the purpose of the statute. You still get your fees. The court looked at Section 1 on business damages and said, yeah, you know, we could do it there, except since there was no offer, we can't do it that way. They talked about that gap again. They said there's no question the legislature intends to pay fees. The statute says they're going to pay fees. It's just a matter of how to compute them. And the holding was, use Section 2 to determine the fees if the trial was to business damages only and there was no offer. If there had been an offer, I think they probably would have used Section 1 and done percentage fees. Now, in LaBelle Phoenix would differ from that because there was a written offer. So there's a distinction between those cases. Okay, some other things that I think fit under supplemental proceedings. To me, your percentage fees are the percentage of the increase that you get in a normal straight condemnation case. The condemning authority files suit, you have an order to take hearing, or you stipulate to an OT. You ultimately, in 90% of the cases, have a mediation and settle a case, or in 10% of the cases, you go to trial. But what about all the other things that you have to do if there's a problem? First one is if you have to intervene. Okay? The DOT, other condemning authorities, they do title work, they send agents out, they try and figure out who do we need to sue. Sometimes they miss people. Okay? I had to miss a client of mine who was a tenant on the property operating a business. Been there operating the business over 30 years. Okay? He was in a building. Now, he leased the parking lot in front of him, and he leased the parking lot in front of him from his neighbor across the street. DOT, and actually this was a city case, the city did their title search and they said, well, the parking lot belongs to Mr. Jones across the street. And they sued Mr. Jones. And we happened to find out about it, filed a motion to intervene, went to court with this motion to intervene, and the judge says, what's the problem? And I explained, and he looked at the city attorney and said, I've been dealing in that store over 30 years. I thought they owned the parking lot. How come you all couldn't figure that out? And, you know, there's a lease. It's not recorded. You don't have to have a recorded lease. And if the right-of-way agent had gone out or the attorney had gone and found out about it, he would have known there was an interest, another interest in that piece of property that he missed. So it could be an unrecorded lease. We have some cases right now where we have some homeowners associations who never got title from the developer to some of the common areas. We know there's an issue. We know there's an issue. So if we have to take the time to file a motion to intervene and get into the suit, we should be paid for that. That's supplemental. Sometimes it comes from bad title work. Deborah Ruster had a case where she represented Ben Hill Griffin, and the DOT filed suit and named Ben Hill Griffin as one of the owners of the property. And Deborah got it, and she worked on it and found out that, in fact, Ben Hill Griffin didn't own the property. So she went back and said to the DOT, my client doesn't own the property. You know, here's the title work. You know, we figured out he doesn't own it. And the DOT says, you know, we're right. We'll dismiss Ben Hill Griffin. And they did. Next step is, okay, Deborah says, how about my fees? The appellate court in the case actually called DOT versus Ben Hill Griffin says, you don't get fees. The DOT argued, Deborah doesn't get fees because her client wasn't an owner. The statute says you get fees if you represent an owner. Her client wasn't an owner. So in that case, she didn't get fees. My suggestion in a case like that is, there's a Florida statute. The Florida statute, and I've got it here, what is it, 57, where is it? 57105. She should have requested fees under 57105. The DOT screwed up. They put her client in the suit he shouldn't have been in. She had to get him out of the suit, and they should have paid her fees that way. So that's another one. Now, how would you measure those fees in a motion to intervene? Or in Deborah Ruster's, where she had to get her client out of a lawsuit that he shouldn't have been in? I guess maybe she could have said, okay, my client owns the property, we'll take the deposit. Taken the deposit, you know, and said, they got whatever we own, they got it. And that, you know, I think sometimes that works. I actually had a case where, not knowing any of that, okay, we had a case, and the county wanted to take property from my client. We ultimately settled the suit. And 3 or 4 years later, the county went to build the road, and the trustees of the Internal Improvement Fund, those people in Tallahassee, said, you can't build on that. That's sovereignty land. And they said, but we paid Stratton's client for it. And they came back to me and they wanted the money back because TIF said, you got to pay the state for it. And I said, hey, you guys said my client owned it. My client thought he owned it, and you paid him for it. It's over. Whatever interest you had, you bought. Pre-OT motions. Any motion that you make under the Rules of Civil Procedure, 1.140B, jurisdiction, you know, I guess you could have that occasionally. I haven't seen that come up too much. But you could have jurisdiction come up. Venue is probably a little bit harder. I can think of one case where I think they weren't sure if the venue should be in Hillsborough or Polk because it was it Polk County taking land in Hillsborough or Hillsborough taking land in Polk for County Line Road or something. So you might have a venue issue. Process. And I did have a case, and it was against the DOT up in Alachua County, where the process, not the surface was incomplete, but the process itself didn't comply with the law. And so I moved to quash the process. So, you know, that's something you don't ordinarily have to do to get your percentage fee. Why isn't that supplemental? And why shouldn't you be paid for that? A motion to dismiss, we talked about that a minute ago. Obviously, if you do a motion to dismiss and it's granted, you know, you've defeated an order of taking maybe, and you get paid. A voluntary dismissal, the ABS case told us about that one. Now, do you get paid if you're successful, but you don't get paid if you're unsuccessful? That I'm not so sure about. I think you get paid as long as it wasn't frivolous. If there was something there, you should get paid for that time and representing your client. Motions to disperse and apportion the deposit, beginning of the case. Stipulated final or stipulated order of taking, or order of taking's entered, the deposit's made in 20 days. I represent the tenant, you represent the landlord, somebody else represents the mortgage company, and there's $1 million in the court registry. And of course, the clerk of the court would like to keep the money. Thank you. Clerk of the court would like to keep the money because they're getting the interest on it, and the judge isn't going to disperse the money if you're all fighting about it. So you've got to get everybody together and agree to get the money out. Should you get paid for that? That's time you would have to spend. The statute mentions apportionment, and I think that's an apportionment. I guess they took 10 minutes of our time, Paul. So we can have it back if we need it. Okay. Well, I'm going to finish up and let Jeff talk. Same kind of issues on apportionment and dispersing. You have a fee owner and an easement holder, and we've got one like that right now where everybody says this never happens, but the DOT says the fee owner is entitled to 50% because the property is encumbered by a power easement, and the power company is entitled to the other 50%. DOT is taking the fee. I don't agree on the percentages. I'm not arguing about the amount of money yet. We're at the beginning of the case, but, you know, so you could have that. A mortgagor, mortgagee, proration of real estate taxes, sometimes it's like pulling teeth. Polk County used to be terrible about telling us how much money they wanted for taxes, and the judges wouldn't let the money go until the taxes were paid. So it sat, and who got the interest? The clerk of the court. And I mentioned that problems with clerks of the court, and sometimes you really have to spend a lot of time, and I know several of us who've actually gone back to the judge, and we put language in our orders dispersing that says disperse forthwith and without delay, because in Palm Beach, when Mr. Dunkel was the clerk, he wouldn't give us the money until he waited like 30 days. And he got a lot of interest that way, and we had to, every once in a while, get him in front of a judge. And finally, he said to us, if it says forthwith and without delay, we'll do it, you know, as soon as we can write a check, which usually is a week from next Thursday. It seems to be, I don't know why it is, every clerk's office seems to say, a week from next Thursday we can write you a check, if you get us the paperwork by Monday before noon. Thank you. Jeff?
Thank you, Charlie. Charlie's just back from Rio. He was visiting that client that absconded with that money, I think. Bonnie, by the way, you're not here, but looks like everybody's still here, if you're counting. In this area, I'll try not to be redundant. There's a lot of redundancy in here. But in this area, one of the first things to tell you, in fact, to tell you about anything in eminent domain, I've been doing it for 25 years, and preparing for this, read a whole bunch of cases. And I thought I knew the cases. But God, there's new cases every day, and I'd really recommend you got to keep up with the cases. And if you're going to do this, you used to be, really, there was a couple dozen cases you had to know, and you could be an expert in eminent domain. really could. I mean, we try to hide and fool you all and say, oh yeah, there's a whole bunch of cases you need to know, but there's really only a few dozen back when we all started, and there's a few of us here from those days like Jim Spalla. But now, there's a lot of cases. So I'd really caution you all to keep up with the cases because you're going to see different ones coming out from the different districts especially. With supplemental proceedings, one of the first ones that come up, and I'm working one right now, are boundary disputes. They come up all the time, either through poor title work or through you have a situation with a developer and association, and property was supposed to go to the association, and now there's an eminent domain case, and who owns it? Well, there's no question in my mind that's supplemental, and we should be paid fees for fighting over that. Charlie's mentioned the LaBelle case, and you know, the funny thing about the LaBelle case, it really had nothing to do with supplemental proceedings to start. On appeal, what had happened was the attorney had tried the case, went for fees, and he asked for fees under 0922, saying, look, it's a supplemental proceeding, right? And he said, well, it was a quick take, and the quick take statute says 74 is supplemental proceedings in eminent domain. Well, the court said, pshaw. But by the way, they explained what a supplemental proceeding was, and they said it really succinctly. They said, it's only applicable when attorney's fees not otherwise provided for are incurred for required proceedings that do not result in a monetary benefit upon which a fee can be based. Even though it went up without that reason, that's some great language, and that tells you clearly what we're all about. By the way, one of the things we have in the written materials, 95361, that used to come up a lot more frequently, and that's the state claiming they own a piece of property by the maintenance statute. It doesn't come up as much anymore, but they're fun cases to litigate because the state has to prove. They have the affirmative burden to prove that they have maintained that property for 4 years in a continuous manner. And I had an old guy in Tallahassee, it was kind of famous, this was a few years ago. He used to actually mow the ditch. So they were claiming they owned way up on his driveway. And this guy, everybody in town had seen this man and his wife, and they were elderly even then, mowing the ditch. So it's kind of funny, the state trying to tell this judge, oh no, we've maintained that for 4 years, and the judge said, since when? And he ordered them to come to court and prove it up, and of course they couldn't do it. Next thing we have is motion to enforce final judgment. There's obviously the deposit of funds issue. And again, some of the same things that happened in the OT money situation happened with after the judgment. One of the places where Charlie and I disagree is, I kind of believe if the condemning authority puts the money in timely, pays their fees, and the clerk just holds it up, I don't think the condemning authority should have to pay its fees to bring the clerk in front of a judge. I just kind of think that's gilding the lily a little bit. Charlie and I disagree on that one. So actually, people who think we're a tag team, we're not exactly. Then there's the issue of contractor engineering, whether through a stipulated final judgment or in a jury trial, a jury verdict, where the plans were put into evidence. It happens, not that frequently. DOT usually acts in good faith. Some of the counties, I'm not 100% sure, but the DOT usually acts in good faith. They say they're going to build a project a certain manner, and they don't. There's been cases, Jim Anderson, my partner, is well aware, where the DOT develops amnesia if it's not written. But sometimes they just don't build it, and you have to enforce. Other times you have to enforce. We had a case down in West Palm Beach where part of the settlement was we get some property. There was adjacent property. We gave up a whole bunch of business damages to get some adjacent property. It was a corner on Military and Okeechobee. The only thing was it had to be cleaned. There was environmental degradation there. It was an old gas station. There was a lot of crap in the ground. So DOT spends a few $100,000, and I'm monitoring it for the client. And then I get told by the surplus property lady, hey, it's clean. So I asked for the property. And guess what? They're thinking they might need it. And we had to go back in front of a judge to say, hey, we want this judgment enforced. And this was several years later. And Judge Stewart, and those of you who have practiced in West Palm, know that he's kind of was kind of a stern judge, and he told Linda Nelson he wasn't really happy with the DOT on that, and he did award us fees. Then you have other issues, again, like the pretrial situation, apportionment of final judgment, like in LaBelle, like the LaBelle. Would you cite LaBelle to say that an apportionment of final judgment? Again, DOT might say, well, wait, we didn't have anything to do with this. We put our money in. We did everything we were supposed to do, but you brought us into the case. And the cases are pretty clear that not only do you get fees for that, but a hearing's not required. Charlie mentioned that in a pretrial situation. That's the City of Miami Beach versus Webster case. Next thing we have in the outline is the expert fee hearings. And that relates again to the Amico case that's cited below this. And many of you are familiar with it. This was another case where it tells you got to watch what you put in your final judgment. You know, that's been mentioned a whole bunch of times today about you got to watch what you say because you're going to be, you know that old petard, you're going to get it rammed. In that case, what happened was the final judgment said all attorney's fees are paid. You know, it was mentioned all attorney's fees. So later they had to go to court, and there was some contested, which, you know, is hard to believe, but there was actually contested motions for cost. Hard to believe, right? That expert fees that DOT just didn't pay them. But actually they spent a bunch of time, and then they asked for supplemental attorney's fees. And the court said, you know, we would give them to you, but you said you got all your attorney's fees. You said you got them all, so we can't give you more. So you got to be very, very careful in that area. We got a case, one of our brothers from Tallahassee, Stanley Chapman, the Teeter case. And again, that reiterates the old notion throughout the law, no fees for argument over amount of attorney's fees, just for entitlement. One thing to add to Charlie's mention of ABS, by the way, you know, there was an old historical ABS about a road going by your house. This is a new ABS. You got to, those of us who've been practicing well, got to be careful there, because how many Patels have there been in the last 20 years? There's been several appellate cases that were Patel, and they're pretty important cases, so you got to be careful. But then in this ABS case, what had happened again, DOT decided to take a voluntary dismissal, and there was a lot of money involved. It was $1.3 million. So the owner asked for 0921 fees, you know, benefit fees. And the court said, nah, I think we're going to go by 0922. And because, again, there was no benefit, the court said. It was a voluntary dismissal, and they made it akin to stopping an OT. The Gatlin case, I don't know if you, the Gatlin, it's pretty self-explanatory. What happened in that case is attorney tried to impact the OT by getting the environmental permits yanked in an administrative proceeding, and he asked for fees for that as part of the eminent domain case. And they said, wait a minute, that's not part of the eminent domain case. That was separate and distinct. Again, I won't mention Patel again. Charlie's already mentioned the Patel case. There's the Skinner case. That's talking really about the appellate fees in a eminent domain case. And they said, look, there was no contingency risk factor in there. So don't come to us with a multiplier. You can come to us with a lodestar, and maybe we'll go up or down if you have you did it unusually well or you did it unusually poor. But don't come to us with a multiplier, because we're not going to give it to you. In the Smith-Bill case that Charlie mentioned before, one of the things that was important in that case is they said a zero offer is not an offer. In that case, what was interesting is they settled the case, they settled all the constitutional issues, they settled the real estate, but they couldn't settle the business damage. They go to court on the business damage, they get $35,000 after trial. So the state wants to pay the $11,000 and change, whatever, 33% on 0921. And the court and the landowner went on to say, no, now, since all the constitutional matters are done, this is now a supplemental proceeding, and you do get paid 0922, and ironically, you wind up getting $35,000 in fees, which was the same amount as the judgment in the case. That's an important case to know, the Smith-Bill case. Some of the other cases we cited, I don't know why we cited. One of the cases you do need to know, though, you need to know O'Donnell, which is a strange, strange case, and maybe somebody's going to tell me why the court did this. In O'Donnell, the attorney owned part of the property. The actual attorney tried the case, you know, and I won't even do the old fool for a client and all that kind of stuff. But the attorney had an ownership interest in the case. And after the case, he wants to be paid under 0921. He wants to be paid straight benefit. And that for life of me, I don't understand why not. The court said, no, if you're the attorney and you have an interest, for some reason the appellate court decided that he should be paid under 0922 so you don't go by benefit. I wish I could tell you why, but somebody smarter than me is going to have to explain that to me, or to you. The Boulos case is important. The Boulos case is very important. You know, Boulos case is important in a lot of ways, but Boulos case was mentioned prominently in the Henry Brown article some months ago. I assume you all read the Henry Brown article in the Bar magazine in October. This one. This is the future. I'm going to get back to this in a second, but this is where condemning authorities want to go with fees and costs. Everybody should read that. It's amazing. Anyway, in Boulos, what happened was you actually had a client who could afford to pay his witnesses as he went along. You know, actually paid him on a monthly basis. After the case, they had a hearing on fees and costs. And I think he asked for like $36,000 in reimbursements or $35,000 in reimbursements, and the court only gave him 16 and change. And Henry cites that prominently in his article. What happened, though, the court said, look, we're going to give prejudgment interest on that because it's actually money that was due and paid. And we do prejudgment interest from the time it was actually paid. It has to be actually paid. It can't be just billed. It has to be actually paid. Garber case is important. One of the things we're all seeing is, especially those of us on the owner side, is the state saying, well, you shouldn't have two appraisers ever. And we're seeing that, you know, fairly frequently. It doesn't matter if the state has two appraisers. Don't do as I say, do as I do, or whatever it is. But they have no problem with that. But that can be very important. Sometimes the state hires somebody who, for some reason, is low bidder or whatever. They don't call it low bidder. What do they call it? Makes the it makes the best presentation, I guess. I read that the low presentation. And they bring an appraiser, sometimes from a few hundred miles away, who really doesn't know the property. Honest guy who doesn't know the property. And now they have to replace him, and they bring a guy in that's a lot higher. And they don't like the fact that we're going to get somebody too. And that happens all over the state. We all know that there's certain districts that make a habit of this, bringing a second person in, one appraiser for OT, one appraiser for trial. We also know that some districts have been known to tell us at the time of OT, look, if you don't accept this, we're going to bring in a lower appraiser. They don't even finesse it by saying another appraiser. They say a lower appraiser. So you have to be aware of that, the Garber case and some of its progeny, because you're going to be faced with arguing it. There's another case that is important, the Owens case. And the Owens case is the last case cited here. And this reminds me of something to tell you. Just because you got a case, those of you who are fairly new to this, doesn't mean you're going to win. Some judges do what they want to do. That's just a fact. Charlie just had a case in North Florida where a judge just ignored the case. And the Owens case is very clear. It's very, very simple. If it is about getting a witness paid, and a judge just decided it didn't matter. And so one of the things about, for those of you new folks doing eminent domain or anything in the law, just be aware that sometimes a judge does what he wants. I was going to mention this article. It's very, very important to read this. This is from the October Bar magazine, and it's really talking mostly about witnesses and not about attorney's fees. Contingent fees for expert witnesses in eminent domain, competency or credibility. And it really, especially the property owners' representatives, you got to read this because, you know, we've fought the fight for some years now. There's been legislation changes planned, discussed, all sorts of things have been floated. This would be horrible for small property owners. If this became the law of Florida, small property owners would be responsible for paying their witnesses as they go along. They'd be responsible for maintaining, controlling what their witnesses are doing. So the property owner who has one piece of property would be competing with the state that is in this business of property. And I really caution you to read this article. It's in the October 2001 Bar Journal magazine, and it's very, very critical. Thank you.